Before going to the relationship between law and liberty, we must know the definition and features of the two words, law and liberty. Law. Law is a set of rules which governing authority promulgate for regulating the conduct of the citizens. This set of rules act as a dictum towards the citizens what to do and what not to do in a society. The basic features of law are: 1. It is definite, clear and precise. 2. It is general conditions of human activities dictated by the sovereign authority. 3. It is the outcome of conscious thoughts, planning and deliberate formulations. 4. Law is equal to all without exceptions. Liberty. It is the ability or power to do what one wants. It is similar to the word freedom. The term liberty is derived from the Latin word liber, means free. Liberty means adequate and proper opportunity for all to enjoy their rights. Liberty implies the presence of certain opportunities which promote the pupil to achieve the best selves. In the word of G.D.H. Cole, liberty is the freedom of individual to express without external hindrances his personality. Hobbes opined liberty as the absence of external impediments. Basically, there are two features of liberty. 1. Liberty means absence of all irrational restraints. 2. Liberty accepts those conditions in which man can enjoy their rights and develop their personalities. While discussing the relation between law and liberty, the legal philosophers were divided among themselves. One set of believers believed law and liberty are contradictory to each other. Law and liberty cannot coexist. Whereas other set of believers believed law and liberty are supplementary to each other. To understand it, we have to go through the negative and positive approach of liberty in terms of law. Firstly, the absolute liberty with absence of law, and secondly, the restrictive liberty with presence of law. Now let us go one after another. First, the absolute liberty in absence of law. To a set of thinkers, law is opposed to liberty. Law and liberty cannot coexist together. If there is interference of law in the individual liberty, then man cannot enjoy the absolute liberty in the fullest sense of the term. The individualists for this reason always wanted to restrict the activities of state at every sphere of human life. To them, law is the necessary evil, and the concept of sovereignty is opposed to the individual liberty. The purpose of the action of the state is to restrict the individual liberty. The individualists always wanted to abolish state. The fundamental purpose of their thought is that man cannot enjoy the fullest liberty if there is influence or interference of law of the state. Second is the coexistence of law and liberty. Another set of thinkers believe law and liberty coexist. If the liberty is not well guarded by the laws of the state, then man cannot develop the inner qualities. If law and liberty do not coexist with one another, then one's liberty will create disturbance over the another. The powerful will oppress the weaker. So, the intervention of the law of the state is essential. There will be imbalance in the society if law did not interfere. The purpose of the state is to promote welfare of the individuals. In the lawless state, the term promotion of individual have no place. The fundamental rights of the individual will hamper. For the proper order of the society, the enforcement of law plays a pivotal role. So, in other words, law protects the liberty of the individual. Whether powerful or weak, no man can attain the best self if the individual liberty are not guarded by law. So, liberties are only protected under law. So, law is the condition of liberty. Dear viewers, to understand this subject in a more meaningful manner, I request you to watch the videos mentioned in the description box and to like, share and subscribe the channel, which will motivate me to make more videos for you. And share your valuable suggestions in the comment section. Thanking you for staying with the channel. From the above discussion, it is quite clear to us that in a civilized society, the state cannot grant absolute liberty. If so, then the term society will lose its presence. Absolute liberty of all individuals will turn the stateless society. The weakest section will be bulldozed by the powerful section, and thereafter the conflict will continue among the powerfuls. The purpose of the state will come to an end, and this is not an expected condition or situation. Absolute liberty will turn the state into tyranny. The purpose of the state is to develop the inner qualities of the member individuals. Law here acts as a balancing force or interface to maintain the equilibrium of liberty of an individual with the liberty of other individual or individuals. So the absolute liberty is impulsive. But when liberty is guided by law, it becomes farsighted. By limiting the absoluteness of liberty, law is providing the space for higher self. At last, we may say, by the word of the philosopher, law does not negate liberty, but support and sustain it. Law and liberty are the two sides of the same coin. Lasky has correctly said, where there is no law, there is no freedom. State is duty bound to protect the individual liberty.